of any presentation you wanted to make regarding damages, how long did you expect that might take?
About 5 to 10 minutes.
Okay. Thank you, Ms. Riley.
Thank you.
I'm sorry. Next position is Bank of America versus Mr. Serdar.
Good morning, Your Honor. Attorney Joy Kandawala on behalf of Bank of America.
Hi.
Hi.
So my review of this one is that it might have actually been a liquidated one that we could just sign an order on, but I'm not sure we had an order from you. I can't remember.
You probably did not. We did file the default judgment package,
Mhm.
and I believe due to a delay on my office's part, your staff attorney was sent the Word version of the judgment this morning.
Oh, perfect. Okay. Excellent. Am I correct though that it was unliquidated, or that it was liquidated, or were there attorney's fees there that needed to be
No, it's liquidated. No attorney's fees, no interest.
Okay. Well, I'll save you some trouble, Ms. Kundawala. I mean, I've reviewed the file last night, and it does appear that, including your motion, it does appear that service was made on April the 26th. The answer was due on May the 27th, and no answer's been filed, and obviously more than 15 days has passed since then. So
That's
I will
correct.
go ahead and enter that order on your client's behalf. Is anyone here that on behalf of Mr. Serdar?
No, I'm here personally.
Okay,
Morning.
Mr. Serdar. So today was set for a default hearing. What you were just hearing me explain to Attorney Kundawala is that the information that they sent indicated that in fact you are in default because the record indicates you were served on April the 26th and that your answer was due on May the 27th and you didn't file one. And so the Bank of America would be entitled to a default judgment unless there is some presentation that you wish to make regarding the amount of any judgment that the court might enter. Do you understand that, sir?
Yes, I do.
Okay. Have you had a chance to talk with Ms. Kundawala regarding any possibility of resolving the case or payments or anything like that, Mr. Serdar?
No, I haven't. I haven't had that opportunity. I kind of was hoping I'd have that opportunity now. I didn't have the information prior.
Okay. Ms. Kundawala, would you be willing, if I were to place you guys in a breakout room to speak to Mr. Serdar briefly regarding any possibility of resolution or payments on judgment or anything like that?
Yes, Your Honor. I'd be happy to.
Excellent. Thank you so much. Mr.
Okay.
Freehoff, can you please create a breakout room for Ms. Kundawala and Mr. Serdar? And just so y'all know, you'll probably get a message on your screen. You have to say yes or something, and it'll take you into that breakout room.
Thank you, Your Honor.
Thank you, Ms. Kundawala. And last position is Cascade Association, Cascade Townhomes versus Melinda Miller. I see Mr. Moore.
Good morning, Your Honor.
Good morning, sir. Obviously, again, I know this is a default, but did you have any, had you had any contact with Ms. Miller or any expectation that she might appear?
No expectation she would be here, Your Honor.
Okay.
All the damages are liquidated, but we're here for the attorney fee request.
Right. Thank you very much, Mr. Moore. Why don't you go ahead with that? Because I know it'll take about a minute or two and we'll go for it. I mean, I'll just save you the trouble that I reviewed the record and it does appear that Ms. Miller was served on May the 17th. Her answer was due on June the 16th and no answer's been filed. And obviously more than 15 days has passed since then. So
Thank you, Your Honor. As you may know, this is a homeowner assessment case. The defendant is an owner of property within the association. She's bound by the recorded covenants. The defendant did not pay the assessments, which brought about this lawsuit. The covenants state that in the event the association has to file a lawsuit to collect past due assessments, that they're entitled to recover their reasonable attorney's fees actually incurred. The association has incurred $2,090 in attorney's fees. I'll state in my place, I'm a senior partner at Lazega Johansson. I've been practicing law for 32 years, specializing in homeowner association cases. I believe the amount that we're seeking is reasonable given our level of expertise and also the provided that the covenants provide that we can recover as well as OCGA 44560 E. The association is asking that they be recover those fees. I will state that we flat rate our fee agreement with our client to keep down the cost and set a specific amount. I believe that fee is extremely reasonable, given the prevailing rates in the area. We'd ask that those be awarded.
Thank you, Mr. Moore. And just to make sure, I'm looking at the proposed order and judgment that you sent over. I'm going to finalize that today. I just want to make sure the numbers are all correct. The $5,618 in principal, $268.04 in interest, your $2,090 in attorney's fees through July 8th, $555 in litigation expenses, and $218 in court costs for a total judgment of $8,749.04. Is that still the right one?
That is correct, Your Honor.
Okay, excellent. Well, as I noted, it does appear that Ms. Miller is in default and that you are entitled to a default judgment, and the evidence regarding your attorney's fees is sufficient. It appears to me they were reasonable and necessary, and that the amount charged is reasonable in the market for what it is. And so, Mr. Moore, we will go ahead and get your client's order on file today. Okay,
Thank you very much, Your Honor. That's all I have.
thanks. Take care. Have a good
All
day.
right. Bye-bye.
Ms. Riley.
Yes, Your Honor.
Okay, so I will start but the same way I have with everyone else, which is I have reviewed your file. It does appear Veterans Roofing was served on April the 15th, and their answer was due by May the 15th. No answer's been filed. And that Thomas Buhan, assuming I'm pronouncing that correctly, was served on May the 8th. And it looks like the answer was due on or before June the 9th, and obviously no answer has been filed. And so both of those entities are in default. But obviously I've reviewed your complaint, and obviously, although the lump sum that Mr. Rodriguez paid to initiate the work is liquidated in the complaint. The remainder of the claims are unliquidated by their very nature. And so now I'm going to throw it over to you to make whatever presentation you'd like to regarding damages.
Thank you, Judge. Yes, there was an amount of $19,584.33, which was paid by plaintiff to the defendant.
I'm sorry,
So-
$19,584.
And 33 cents. Yes, Judge.
Thank you very much. Go ahead.
Essentially what happened is the plaintiff entered into a contract with the defendant in May of 2023 for a roof contract, or it was a roofing contract for the installation of a new roof. Following this, defendant Bohan got arrested multiple times for things like theft by conversion of property. I think there were 4 arrests for theft by conversion. This is kind of a thing he's been doing over time. He takes the money, promises to install a roof, doesn't install a roof. So they entered into this contract in May of 2023. Plaintiff paid to defendants that amount that I just mentioned. And then essentially nothing ever happened. Plaintiff couldn't get a hold of defendants. Defendants wouldn't install a roof. So we are seeking recovery of that amount that I just stated. However, we are seeking to recover that under our unjust enrichment claim. And we are also seeking to recover under fraudulent misrepresentation and inducement, as well as punitive damages, and then of course my attorney's fees.
So in other words, instead of seeking to recover the contract damages, your argument is that your client was fraudulently induced into entering the contract based on false representations that Mr. Bohan made, and therefore
Yes.
you want those the unjust enrichment and fraudulent inducement instead. You're electing those and rejecting the contract, correct?
Yes, Judge, as I believe those fraudulent misrepresentations would have deemed that contract void, and so we would seek to recover under unjust enrichment in the alternative.
Well, given the
Or
allegations of your complaint and the fact that they're now deemed admitted, then I agree with you that there is a factual basis for you, legal basis as well, for you to pursue those claims. Go ahead.
Thank you, Judge. And I have the plaintiff here, and I can submit his testimony just in support of these claims.
Okay, go ahead. Mr.
Yeah.
Rodriguez, will you raise your right hand, sir? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you, sir. You may lower your hand. Go ahead, Ms. Riley.
Thank you. All right, Mr. Rodriguez. Did you enter into a contract with defendant Veterans Roofing and Thomas Bohan?
yes,
And was this contract for the installation of a roof on your property?
that's correct.
Okay, and when you entered into this contract, did he make assurances to you that he was going to install a roof on your property?
Sure, yes,
Okay, and did he make these assurances and tell you that it was going to be completed timely?
of course, yes.
Okay, and Did he complete a roof on your property after you entered into the contract?
No.
Okay. Do you believe he made these assurances regarding the installation of a roof on your house to get you to enter into that contract with him?
Well, yes.
Okay, and in doing so, you paid to the defendants $19,584.33.
Yes.
Okay, and do you believe that an award of punitive damages would help to deter this conduct from the defendant in the future?
Yes, I hope so. Yes.
Okay. And have you had to incur attorney's fees and pay myself to bring this matter before the court?
Yes.
Okay. And that's all for the testimony, Your Honor.
Thank you. Ms. Riley, anything else? Any other evidence you're going to offer other than just argument?
No, Judge.
Okay, go ahead.
So we are seeking an award from this court under our claim of unjust enrichment in the amount of $19,584.33. We are also seeking an award under our claim of fraudulent misrepresentation in amount of $5,000, an award of punitive damages of $5,000, and then my attorney's fees, which I will state in my place. I am an active member of the Georgia Bar in good standing. I have been licensed since 2021. I practice in Peachtree City, Georgia. My hourly rate is $400, which is standard in this area. And to date, let me see, we charge hourly, so I'm trying to do the math today. My client has incurred $4,360 in court costs and attorney's fees.
$4,360
Yes, Judge.
in court costs and fees.
Yes.
Okay. Okay. Excuse me. So as I said, I'm sorry, anything else, Ms. Riley?
No, that's all, Your Honor. Thank you.
Okay. So as I said from the beginning, it is obviously, I think the record demonstrates that both the defendants are in default. The unjust, and I don't have any problem with the theory of recovery that you are pursuing on behalf of Mr. Rodriguez in terms of what's demonstrated, what can be proven based on the deemed admitted facts in the record. And I think there is a basis for, based on those, for the court to enter judgment on the count of unjust enrichment in the amount of $19,584.33. I think that the attorney's fees that you are seeking regarding on Mr. Rodriguez's behalf in the amount of $4,360 is sufficient. However, and I also think that your client is entitled to damages for punitive damages and fraud, given the just complete fraudulent activity that occurred here in terms of just taking money for something that he did not intend to do. And so I will give you the damages for fraud in the amount of $5,000. But I'm actually going to award $10,000 in punitive damages, primarily because I think that honestly, I would order a higher amount if I didn't think it would at some point reach it'd be so egregious that, you know, it might be, it might jeopardize the enforceability, et cetera, of Mr. Rodriguez's judgment. It should be higher. This behavior absolutely is unacceptable. It shocks the conscience. It is not how business is done. And it is, I think, necessary to attempt, I'm not sure it will with this gentleman, but to attempt to discourage that behavior in the future. So what I'm going to do, as I said, just to make sure, because I'm going to ask you, Ms. Riley, if you will submit a proposed order that demonstrates that the defendants are in default and that the court has awarded $19,584.33 in damages as to the unjust enrichment claim, $5,000 in damages as to the fraud claim, $10,000 in damages as to the claim for punitive damages, and attorney's fees in the amount of $4,360. And that will be with statutory interest to run from the date of the judgment. If you will send me that proposed order, I will get it on file for you as soon as I can. And then good luck trying to execute on it.
Absolutely. I'll get that over to you today. Thank you, Your Honor.
Excellent. Have a good day, Miss Riley and Mr. Rodriguez. Thank you for your time.
Thank you. May I be excused?
Yes. Okay. And Mr. Sudar, am I pronouncing that correctly, sir? You're muted, sir.
Hi, yes, that's correct, yes.
Okay, thank you.
Good morning, hi.
Good morning, sir. And I see that Ms. Kundawala, are you back? Yes. So I
Yes.
see that both of you have returned from a breakout room and had a chance to speak. Any announcements to be reported from that conversation?
Yes, Your Honor, we've reached a tentative agreement
Okay,
to resolve the account. I just need to get Mr. Sardar a consent judgment
Mhm.
and then get that to the court. I did get his email address so I can expedite that. I hope to have that to him this afternoon or sooner if possible.
Okay, that
So
would be, that's excellent. I'm glad that y'all had a chance to speak and get that worked out. I will look for that consent judgment. Again, because it can be done electronically, I imagine we can do it pretty quickly. But just to make sure it stays on everybody's front burner, if y'all can make sure that it gets accomplished by tomorrow afternoon, that it gets fully executed and to my staff no later than tomorrow by close of business, then we'll make sure and get this, judgment entered for you guys, and this case will be resolved.
yes, Your Honor, and if something happens and we don't receive the executed consent judgment, I'll reach out to your staff attorney to let them know that we'd like to proceed with the default.
Of course. And then if that happens, what we'll do is we will simply, proceed with the default based on that email address. Because as I said, there is a basis short of y'all's agreement. There is a basis for the court to enter that default. But I'm going to hold off on doing that based on the parties' announced agreement. And I will look forward to that agreed resolution coming in this week. Okay.
Okay, thank you so much, Your Honor.